I tell you what, if and when you want Nick to talk on this initial subject, say Nick whatever, so that we don't step on each other in talking about the same subject if we're being asked about the same subject. And so work with each other. I would help him when he had a case to try and I had nothing to do, and vice versa. So we had occasion to work quite well together in each other's courts as prosecutors, assisting each other. Thereafter, we had been in there for about 5.5 years. Austin Anderson had died. Hubert Green was appointed, and we worked with him, of course, and the people that were in his office at the time. The time came, however, when I felt that it was time to move on. And from the standpoint of politics and all that, it was a real good time because Hubert Green had not had anybody announce against him at the time. There was no big heavy case pending or hovering over the office that someone would say or might say that we ran away from. And so we gave Hubert 3 months' notice of the fact that we were going to leave, because we knew that the positions, of course, were of consequence, and that he would have to find someone in due time. So we left the office. Well, we gave him notice that we were going to leave August the 15th, which we did, and we opened up in the Frost Bank building. From the very outset, and if you will phonetically sound Nicholas and Barrera and Nicholas, Nicholas and Barrera phonetically rhymes and smooths easier. So it was my thought that his name should be first. However, there was a question of the offices, and that's where the card playing came in. And there wasn't any five, there were 3. And initially it was supposed to be resolved with 1 flip of the card. And when I won, which I didn't want to, then Nick said, let's make it 2 out of 3. So sure enough, he won. And so it became Nicholas and Barrera, and I had the choice of whatever office would be thereafter acquired by either one of us from then to ad infinitum. And that's the way it's been.
You went into private practice almost 50 years ago and became partners. Mr. Nicholas, Mr. Barrera said that y'all went to the Frost Bank building. Was that the Class A office space in San Antonio at that time?
Well, as far as we were concerned, we liked the old Frost Bank building. It had been there forever, and everyone knew where it was. So I don't think we ever looked at any other space.
And at that time, from 51 to 57, when y'all were prosecutors and then in private practice, what type of cases were you prosecuting, and what type of cases did you begin to defend when you went into private practice?
Well, as prosecutors, as chief prosecutors, Roy and I tried all of the major felony cases, the capital cases, aggravated robberies, rapes, murders, things of that nature. And then we participated in whoever the second chair prosecutor was, and them being able to learn exactly what to do and how to try a case and to argue a case. And of course, when we left, there was quite a bit of publicity, and in that day and time, cameras and reporters were allowed in the courtroom. And so when we resigned and actually started to practice, there was an article written by Howard Hunt, who was a reporter in the, I think it was the Express News at the time, announcing our leaving, and so it was kind of an invitation to all of the would-be criminals to get a hold of us.
I think they're called citizens accused.
Citizens accused of crime. And so naturally we started defending criminal cases. And we stayed in the Frost Bank building. I think we moved a total of 3 times in the building, in the Frost Bank building. And then we built our office here right after Hemisphere, and we've been here ever since.
Well, it seems like we've got excellent memories here, and I'm sure you have a treasure trove. What about some cases, first of all, as prosecutors with the Bexar County District Attorney's Office, Mr. Barrera, what comes to mind with a story you would like to tell, or cases that you think about, or proud of, or that most memorable to you?
There were any number of cases, at least in my court, that I recall, and that of course, I enjoyed trying all cases. It was my theory, whether the cases were good, bad, or indifferent, that I wanted to get as much experience as I possibly could with juries, with other lawyers, and so forth. It was my theory that from the good lawyers you learn how to do it. From the bad lawyers you learn how not to do it. So it was a benefit, whatever we did in trying of these cases. There were two cases that, in my opinion, were outstanding, at least during the time that I was there in my court, and that was the Alvaro Alcorta case. That was a case that became very, very controversial. That case went to the Supreme Court, and it was argued there by me and by Hubert Green. The case was lost. We were alleged to have suppressed evidence. That was in the very, very beginning of the changes that were anticipated by the Supreme Court insofar as what duty the state owed the defendant. We took the position that what we did not give him, knowingly did not give him, it was because he wasn't entitled to it. The Supreme Court ruled otherwise, and that was an outstanding case in my recollection. Another one was a police officer who had killed his wife, shot and killed his wife. Hubert Green and I tried the case and obtained a death penalty for him. Also, the case was reversed on a technical point that, again, was relatively new. That was the issue of insanity coming up, raised by whatever source during the course of a trial. The judge had to stop the case, look into the question of insanity before going on with it. At that time, that was not the style, that was not the law, and of course, when that issue came up, we disregarded it. And the Court of Criminal Appeals decided that we should have stopped the case and looked into the issue of insanity. So that case was reversed. And thereafter, both defendants pled to lesser number of years, but they were still very, very substantial. Those two cases come out and stand out in my mind as cases that I prosecuted in my court. There were many others of equal consequence, but not really from the standpoint of publicity as this one. There was one other, and I will turn it over to Nick into his court. There was a case where in the city some police officers had shot and killed a black citizen bartender over on New Braunfels Street. And that was a case in which it was determined. I was one of the investigators in the case, and there was another investigator. We investigated the case, and we determined that, one, the police officers had filed false reports of self-defense. They had substituted evidence in the records of a knife that they had picked up on an earlier case. They planted it on this black bartender and alleged that he had pulled a knife on him, and that they had had to shoot him. The city council stood by them. The police chief stood by them. There was an organization or citizens group that descended on city council, and they were rejected. Austin Anderson, who was then district attorney, caused us to go ahead and start investigating before they even got over there to our office. We did, and it was determined that these fellows had in fact willfully shot this man, not all three, one of them, and that they planted the knife in unison and held to that story. Well, we were able to prove otherwise. The case was indicted. The police officer was indicted for murder. The case was removed to Jourdanton on a change of venue. The case was tried over there. It was a bad venue for us. The policeman had been from that city or from that community, and so had the others. And so a jury of tried and true citizens in Jourdanton found the police officer not guilty, notwithstanding that he agreed and confessed to having been negligent in having put the pistol to the black man's head and played Russian roulette with him. They were trying to get him to open a safe that was in that bar. That the man said, "I don't know the combination. I guess you're going to have to kill me." And although we later determined that it wasn't the intent to kill him, but that he had been grossly and crudely negligent in what he did, putting that gun to his head. But that was another one of the outstanding cases that I recall.
Anthony, you had time to think about some cases? I mean, naturally, you had a lot longer time as defense counsel, but I wanted, just for recollection, some cases you might recall prosecuting.
Well, the the one that comes most to my mind is when I tried the Teamster Union president, Ray Schaefer. There was a war going on between the union and non-union, and there were bombings and shootings and things of that nature that were going on, and the politics at that time was not to really upset the union, because they had power to control a lot of votes. You know, when your DA ran for office and such as that. There was an old Texas Ranger named Zeno Smith that brought in the case, and at that time no one seemed to want to indict the Teamster Union president. Well, anyway, I took the case with Zeno, and we obtained an indictment, tried the case. Joe Frazier Brown was the judge. I prosecuted it, and John Peace, who was more or less famous at the time as a defense lawyer, and one of John Conley's big supporters, defended the case. The case lasted 6 weeks. The jury, it so happened that the girlfriend of Schaefer, the Teamster Union, ended up on the jury. And so, although I thought it was one of the most, well, it took 6 weeks to try it, and at that time it was probably the longest criminal trial around. And the jury was out quite a while, and they came back and acquitted Schaefer, because that particular lady on the jury, swung the jury her way after about 6 days of deliberation. And so we lost that case, but after that there was practically no violence that was asserted from the union to the non-union people. Jim Onion, one of our ex-prosecutors, was representing one of the manufacturers that they were trying to get to join the union and trying to force them to. And there were many others, like Roy knows about most of them. One of them was the Elizabeth McCarter case, where she had killed her husband's paramour, and it was defended by one of the most well-known lawyers then, Freddie Saman, and I think his partner, Lou Schlesinger. And,
right.
And normally that would have been an acquittal. The jury went out and convicted her and gave her 20 years, which was unusual in this county at the time, because paramour killings were not really that big a deal then with juries, and they usually came in with acquittals. So that kind of turned the tide and probably caused more people to get divorces instead of shooting each other. So there were a number of others, but you know, we could go on forever. So
let's talk about your work as defense counsel when you began in 1957. When you began, and clients flooded into your offices there on the 10th floor of Frost.
11th
floor. The Frost Bank building. What were some very early cases that y'all recall? Because they must have been important to you, being some of the first ones that came through the door.
Well, probably the ones that people might remember would be, in the very beginning, there were all kinds. There were aggravated robberies and rapes, murders. I remember the first case was an aggravated robbery case that I defended, and the defendant was a person that I prosecuted early on in the DA's office. And so I went to the first assistant at that time, who was Dick Woods, later became the judge, and had him waive a conflict of interest so I could defend the guy. And I remember the lady came in. She kind of looked like a bag woman or a street person, and she was a mother of the defendant. I won't call his name now, but he's deceased now. And I figured, you know, they couldn't pay much of a fee, and I really didn't know how to charge fees. So I just picked $12,000 out of the air. The lady picks up this bag and puts it on the desk, and she reaches in there and pulls out all this cash. And so I told Roy about it later, and he said, well, you should have asked her for 15. And anyway, that's the way we started out. And we'd set our fees and try to collect them up front. And then after that, you know, more well-known cases came in, like George Parr, Duke of Duval, and Glenn Martin, and Oscar White. They were trying to indict them for the Alamo City contract that almost broke the city at the time, and many others. Roy probably remembers more than I do about them. But anyway, that's kind of how we got started.
And with that lead there, Mr. Barrera, what cases come to your mind?
Well, one of the first cases that comes to mind, of course, is the Alcorta case that I went to the Supreme Court on, because I was no longer in the office at the time that case went to the Supreme Court. And Hubert Green, who was still district attorney, of course, asked if I wanted to participate, and I told him absolutely, provided and conditioned the state pay me. And the state did pay me, and I went up and argued. That was an outstanding event for me, because again, it's a rare thing for a lawyer of any consequence to go up there and argue a case for the Supreme Court. But more outstanding in my mind and memory, insofar as being a defense attorney, was the one where Judge Buck Jones appointed Nick and myself to represent a soldier by the name of Bill Flanagan, who had shot and killed a service station operator over here on the Austin Highway. He had stolen a pistol from the military where he was stationed there at Camp Hood, and with this pistol he shot and killed and robbed this man here in San Antonio. Thereafter, for whatever strange reasons motivate these people, he decided he wanted to go to California and see a little girlfriend who was underage, who was locked up as a juvenile in California. And so he decided to go to California to see this little girl, and he took his pistol with him. Notwithstanding that he had a girlfriend there at Camp Hood who didn't like that too well, he liberated this little girl from the juvenile office, went over into Mexico. On the way over there, he knew he couldn't take the pistol across, so he threw it out on the road somewhere. Coming back from Mexico, he decided he wanted that pistol after all. So sure enough, he looked for it and he found it, brought it back, took the little girl back to the juvenile home, and came back to Camp Hood. On his way back, he picked up a hitchhiker, and he robbed and killed that hitchhiker with the same pistol in Arizona. And in fact, the county was Cochise County, and we had occasion to remember the sheriff of Cochise, which was a prominent TV serial at the time. In any event, Bill Flanagan came back to Camp Hood, and he got into some arguments with his girlfriend. His girlfriend reported to the military that Bill had stolen that pistol, and that he had that stolen pistol. They came and took it from him. They routinely test fired it. They sent the bullet routinely to Austin, and the examiner at that time was a fellow by the name of Reimer, and he was the best. He examined the sample bullet that had been fired from the pistol routinely, and he cataloged it. He told us later on that about 3-4 weeks later, that he had been asleep at his home, and all of a sudden he woke up with a start, recognizing that the sample bullet that came in from Camp Hood bore a striking resemblance to the one that had been taken from the dead body here in San Antonio of that service station operator. He thought so much of it, he got up at 2-3 o'clock in the morning, went to his lab, took out the sample and the proffered bullet, and determined that they were and had been fired from the same gun. He immediately reported it to the military. They arrested Bill Flanagan. Thereafter, they tried him for murder. Hubert Green, our former boss, was the prosecuting attorney. Nick and I were the defense attorneys. And we lucked out and settled that case for life in the penitentiary for the simple reason that Hubert wanted to try him for the death penalty, and we obtained and got a psychiatrist who informed us that Bill Flanagan, after his examination, an examination for which Nick and I paid. At that time, they just gave you the client. They didn't give you any money when you were appointed. And the psychiatrist examined Bill Flanagan and determined that he was less than all there mentally. And of course, we used this to persuade Hubert to come down to a sentence of life as opposed to trying for the chair. That was one of them. And thereafter, almost immediately thereafter, again, Judge Buck Jones appointed me to represent a fellow by the name of Brown, who had killed two people out here in some country road who were very close friends of Sheriff Kilday. And, of course, there was a lot of heat on that case because of what he had done, how he did it. And M.C. Gonzalez was appointed to also assist in the prosecution of that case, in the defense of that case. And we tried the case and got a hung jury on it, and thereafter it went to Cuero, and another lawyer was appointed to represent him. But I did tell Judge Jones at the time that I had not gone to law school to represent every indigent murder defendant that came down the road, and he said, well, he appreciated that, but at that time, Nick and I were so freshly out of the DA's office, we were up on what the law was and so forth, and he felt that we could easier represent him. In any event, that was a second case that I do recall quite well. Nick may remember also the case that we both represented. There was a feud between two families, the Mercados and the Rubios, and they were killing each other like flies. We wound up representing the Mercado side of the family. Rudy Esquivel was representing the Rubio side of the family. And one day, one of our clients of the Mercados had been killed by a Rubio. And Rudy Esquivel called and asked if we could settle this thing and probably get these families to stay off of each other's back and not have any more killings. And in joke, of course, but somewhat serious, I told Rudy, you're one up on me. I'll let you know when we can settle this thing among the families. So sure enough, not too long after that, one of the Mercados killed another Rubio. And I called Rudy. I said, Rudy, now we can settle and arrive at an agreement. It was an interesting case because of the consistency of the feud between these two families. There were many other cases. One of them was a colonel, Colonel Harrington. Colonel Harrington had been involved with the Atomic Energy Commission at the time, which was high priority. And apparently his responsibilities were such, and he was so closely connected to it, that it began to fray on his nerves. So much so that on one occasion, in frustration, he ripped open a suitcase that he had some pistols in, pulled out one of the pistols, shot at and killed his wife, and shot at and permanently injured his son. Of course, the colonel was immediately taken over by the Air Force and locked up, charged with murder. It was a state jurisdiction also, and so he was indicted by the state court for murder. There were two lawyers who had been in the military but were now civilian lawyers, but they were well up on military law, and so they wound up representing him in the Air Force case. In the state court, Jim Barlow at that time was a prosecutor, and he wanted to try him full tilt. The problem was, and the military had made it known to us, that the colonel was restricted in what he could tell us about the secrets that he knew and so forth and so on. We took the position that whatever he knew, regardless of whether or not it benefited the government or not, we had to exact from him everything that he knew and what had caused him to do this. It became quite delicate, and so we prevailed upon Jim Barlow to give us a 5-year sentence to run concurrent with the 5 years that the Air Force had given him. and so he served with the Air Force for 5 years, and that was the end of that case, except that the last time I heard about Colonel Harrington, as big as he was selling hamburgers in Waxahachie. And it was a real interesting case, and it was one that created problems for the prosecution and for the military. They couldn't let him go. They couldn't let him out of their sight because they were concerned with all that he knew.
The national security defense.
Exactly. So there were a number of interesting cases that we had occasion to represent, both jointly and thereafter, when things got a little easier financially, why Nick would represent his clients and I would represent mine, although in essence they belonged to both of us. And incidentally, with regard to the beginning of our partnership, to this day we have nothing in writing reflecting that partnership. We started out on a handshake where we would split the costs and split the fees, and that's been the agreement from and since that time to the present time.
That's an honorable agreement, and also with nothing in writing, it protects both of you.
Absolutely. Absolutely.
Anthony, all these years of practice, and here on these cameras, and later many lawyers I hope will see this and take from each of your comments, but can you give any advice or reflect upon what you've learned as a criminal defense lawyer and what you might impart to us in our practice?
Well, I learned, of course, a long time ago that the most important thing in defending or prosecuting a case, criminal or civil, is investigation and being real familiar with the scene of the crime or of the accident, and knowing the background and who the witnesses are, where they come from, whether or not they have criminal backgrounds or any other kind of problems that they may have had in the past. And of course, making an informed opinion of your own as to what your defenses are, whether or not you could sell them to a jury, and how legitimate they were, whether the client was giving you all the facts or not, and being so totally prepared that if you couldn't make some type of plea agreement that was favorable and acceptable to you and your client, you were prepared to try the case. And I put a lot of emphasis on the way the client was dressed and the way that you were dressed, and trying to get a jury that would listen to the facts. And you just develop techniques as you go along, and you got to figure out when you're voir direing a jury as to what kind of jurors you want and who you need to strike and who you need to consider on the jury. And of course, you can't get everyone you like, so you can at least end up getting jurors that will listen to what you have. And I usually defend it on the basis of kind of a single shot defense rather than a shotgun defense, where I would, if it was a self-defense case, well then I would zero in on self-defense and not be concerned about a lot of other defenses that you could argue but that weren't supported by the facts. And I've always, first of all, if you have a case where you know the client is real guilty, which is usually the case, then you try to make the best deal you can. If you can't, you try it.
I'm glad you mentioned that, because you enjoy a reputation in the community as one of the best deal makers or negotiators. Other than your preparation and investigation, anything there about negotiating with prosecutors on achieving the best result for your client?
Well, if you're well prepared and you know what you're talking about, you have a better chance of negotiating something that's would be beneficial to your client. And on the former question you asked about other cases that I defended, I probably left out one of the most important, which was when I represented Associated Milk Producers before the Watergate hearings. And the president and the party who put that organization together, plus 2 or 3 of his lawyers and things of that nature. I spent a lot of time in Washington at that time, which was quite a while ago. I appeared before Judge Barrera and Judge Hart, and we ended up coming out real well in those cases. And as far as that, I mean, we could just, like I said earlier, you know, we can go on and on about.
Let me give you a prompting. Both of you practiced in federal court here in the Western District of Texas in San Antonio, and there we have our courthouse here that's named after John H. Wood, and both of you practice in his court.
Right.
And many people would know that he was killed. He was shot here in San Antonio, and ultimately Jimmy Chagra was charged with the offense of conspiring to kill him. Did you have any participation in that case?
Well, in the beginning I did. I was retained by a lawyer in Las Vegas who's now the mayor to see if they could work out.
Mr. Oscar Goodman.
Oscar Goodman. They wanted, early on, they wanted to see if they could work out a plea for their client. And I think Rusty Geyer and Murphy were representing the government in that case. Is that correct?
That's correct.
We negotiated a deal in El Paso in the very beginning, which was rejected by Chagra. And then, of course, later on, y'all tried it, and also the person that that was a trigger man. What's his name? Harrelson, and obtained your conviction. But in the beginning, Chagra could have made a pretty good deal for himself, and so that was my participation in that particular case.
Mr. Barrera, you a case which I think you recently wrote on in the San Antonio, the Criminal Defense Lawyers magazine, and one that's often commented on that showed a showplace for your talents was a death penalty case on the killing of a highway patrolman.
Oh yes, yes.
And I don't know, I should be able to say as being prepared for an interview the name, but I know that Ward Casey was the prosecutor in
exactly.
Ellis County, I believe.
Yes.
The county seat is Waxahachie. You mentioned
yes.
a place where was it Mr. Flanagan or Harrigan was selling hamburgers.
Right, right. Well, what I recall about that case, in fact, Nick was involved in it initially. It was a particularly bad case in the sense that there were 3 Hispanic young men who had gone to Dallas from San Antonio. They went up there to work as roofers. They found out that working as roofers in Dallas was just as hot and just as hard a job as it was here in San Antonio. They worked up there for about 30 days or so. They decided they wanted to come back home, but they could not get paid because contractually they were obligated to stay there another 2 weeks. They stole an automobile. They broke into a grocery store, stole some beer, and they were merrily coming back to San Antonio in this stolen automobile when they picked up 2 GIs dressed in civilian clothes who were coming back to Camp Hood, or Fort Hood as it's called now, and they were soon picked up by a highway patrolman because obviously they were speeding. Well, a brief investigation by the highway patrolman revealed, one, that it was not their car. They had no keys. They had hot-wired the car, and in the course of his investigation, the younger of the 3, who was 16 years old, decided he wanted to jump that highway patrolman, and he asked my client, who became my client, he wasn't my client at the time, to help him jump the patrolman. We had read about this case in the paper, but it came to our attention in our office when Mr. Nicholas came into my office. We were in the Frost Bank building on the 10th floor by this time, and he came in and said there was this lady, Hispanic lady in his office, and he says, guess who I've got in my office? I said, who? He said, this lady, she is the mother of one of the boys that killed that highway patrolman in Dallas. And I said, so what do you want with me? And I knew it was a bad case. And he said, well, I've explained to her that she doesn't have any money. And several lawyers have quoted her some high fees, and of course appropriately, but they don't have it. So in any event, to make a long story short, I wound up being inveigled, if not induced, by this lady to represent her son. It became exemplary to me that a lot of the things that we as lawyers do sometimes are not exactly what we ought to do. I was trying to convince her that she need not worry, that they would appoint a lawyer to represent her son, and he'd have a representation and so forth. But down deep I felt, one, the place where this had happened, the ethnicity of these boys, and where they were going to be tried, or at least this boy was going to be tried. It was not in the best interest of this boy to go up there and have a court-appointed lawyer for him because, again, as those things go, the appointed lawyers are not paid. They might hold his hand while he received a severe, if not death penalty. So I felt a little guilty about advising her to go get a court-appointed lawyer. Wound up taking the case. And I went up to see the boy in Waxahachie. And it was a peculiar set of circumstances, and I don't want to make it too long, but he advised me real soon that they were treating him all right, except that there was a big fat deputy sheriff who was telling him that he was a Mexican SOB and that they were going to burn his ass, as he put it. And I told him, I said, well, now don't give them any reason to get upset with you. Don't give them, these guys around here will shoot you in the back and say that you were trying to escape. These boys had come to San Antonio after this happened, turned themselves into the sheriff here, and the sheriff here delivered them to Waxahachie. So they were not there to run away from anybody. But the bottom line was that when he told me that, I went to see the district judge. I told the judge over there, I said, Judge, you know, this boy's in your jail. I'm representing him, and he tells me this, and I repeated what the boy had told me. I said, it well may be that he's a Mexican SOB, and it well may be that y'all are going to burn his ass. However, I said, I want you to know that it's your jail, and if anything happens to this boy before he is tried, I said, you're going to have more FBI agents down there than a dog's got fleas. Oh no, nothing like that's going to happen. Well,
what year was this?
This was about 1968 or 69. I just left the Secretary of State's office in 68, early 68, 69. It was in 69 or 70, 1970. So we tried to pick a jury, at least the state did, I didn't try, and we wound up finishing the panel with picking only 6 jurors, and we still had 6 more to go. Ward Casey was the district attorney there at that time. I had asked for an examining trial. He said no, he was going to indict him, and he did indict him before I had an opportunity to have any hearing on it. The case was then when we were unable to get a jury, the judge then transferred the case to Dallas. And of course I felt it was out of the frying pan into the fire. And the case was assigned to a Steve.
I think there, Mr. Barrera, it would be from the fire into the frying pan.
Yes, I guess.
I
guess. So the case was assigned in Dallas to a prosecutor by the name of Steve Tokley, who was their felony case, capital case prosecutor. Allegedly, and I don't know this, it was said that he had never lost a capital case before. So I went there, of course, to try the case. Ward Casey did not want to release the case to the Dallas people, so he came with it. He brought his county attorney, and so I wound up having 4 lawyers on the other side as prosecutors against my defendant and myself. Of course, he had 1 lawyer as opposed to what obviously was 4 on the other side. I felt from that standpoint of the facts that the facts were the same. I didn't care how many lawyers were on the other side. I felt that they would be at a disadvantage because they had never tried cases before. Tokely would not let the case go because he said he didn't want any hick-town DA coming up there and messing up his prosecution record. To try to shorten it up a little, we tried the case fully. The jury found the boy guilty of murder without malice, which immediately put a 5-year cap on it. And thereafter, I still had the gumption to ask that jury to give us a probated sentence, as they had assured me they would. And 3 of the jurors, the judge told me later, wanted to give him probation. They finally arrived at 5 years because by that time we had bifurcated trials, and the second portion of it was in that instance. So absolutely, I just felt top-notch in having had the opportunity to go up to Dallas and to represent that boy in a very, very delicate and bad situation. Fortunately, they saw it our way when I got through explaining, and when we put on our evidence and so forth. The jury was very sympathetic to us, and they did what they did, and it was one of the highlights of my practice. All of these cases that Nick and I have tried to a great extent have not been necessarily nationwide publicity-producing cases, but they have been cases that have been hard to try, difficult to represent, and we've had ample opportunities to have good successes in them. So we've prospered well in that direction from the standpoint of being able to represent these people.
Both of you have families, I'm sure, that must think of you, both of you, in their prayers for, I'm sure, that young man that you represented, and that he ended up with a 5-year sentence. That's just an absolute win.
Absolutely.
Concerning the circumstances, and regardless, and each of you have been made a decent living, luckily. But there are those rewards that you get from helping people that are accused, and also their families. And Mr. Barrera, so what would you, I asked Mr. Nicholas a moment ago, what would you like to impart for all of us still practicing, as both of you are?
The only thing that I can give you in that regard is the benefit of my own experiences. We know, I think, as defense lawyers and as triers of cases in the courtroom, that it's a hectic, up and down, very traumatic experience for any lawyer to try a case in a courtroom with juries. And I learned early on that I should not take those cases to heart, or the defendants that were involved in them. I learned that you cannot marry your client emotionally, or he'll take you to the penitentiary with him, or he'll take you to the death chamber with him. Luckily, we never had anybody that was convicted or sent to the electric chair while in our practice up to this point. But I learned that you cannot emotionally get yourself involved with your client. You owe him all that you can as a lawyer. Everything and every effort that you can expend in his behalf, legally and factually, to get his case before that jury to the best of your ability. You owe him nothing more. You don't owe him any emotion on your part or any heartbreak on your part. I wouldn't take those things home with me. I wouldn't discuss them at home. I would leave them at the courthouse, or leave them at the office where they belonged, because to do otherwise is to damage yourself emotionally. Many lawyers have been caused to take to drinking because sincerely they feel for their clients, and it's not an ill feeling or a bad feeling or a bad emotion, except that it can destroy you. If you try enough cases and have enough defendants in that courtroom who suffer the consequences of their offenses, they can take you with them. So I learned early on, you don't owe them your emotions. You owe them everything that you can. Another question that is always asked of lawyers, and I'm always puzzled at how some of these lawyers wrestle with that, and that is, you're asked, how can you defend a fellow who you know is guilty of the commission of a crime? How can you go into that courtroom and get him off? Well, the objective of a lawyer going to court to represent a client, in my opinion, is not necessarily to get him off. although that happens. If you do the best you can to represent him as he should be represented, your duty and your responsibility as a lawyer to any client is to allow him and to get for him all that the law says he's entitled to, both from the standpoint of the facts and the standpoint of the law. If that results in a guilty man being set free because the law dictates it, then that's the way the law is supposed to work. If he is convicted, notwithstanding your efforts, that's the way the law is supposed to work. All that you owe him is the best that you can do with your knowledge, with your experience, with your training, to represent him and get him the benefit of each and every law that he's entitled to, and nothing more. So the job, in my opinion, of a lawyer is not to get a client off, as the case may be, but to represent him properly. That oftentimes results in a client going free that possibly should have been convicted, but that's because the law dictated that if the law is presented and the law is in favor of this defendant as the accused.
Mr. Nicholas, all of us here know that at the end of 2006 you celebrated your 80th birthday, is that correct?
December 1st.
Okay. And it wasn't too long after that that your partner, your younger partner, also in January of 2007,
right.
Was still with you on his 80th birthday.
Right.
So
yeah, I'm the oldest.
Okay.
But
He's the old,
another reason for it to be Nicholas and Barrera.
he's the old man in the firm.
So at 80, here we are at y'all's offices here on the corner of Presa and Nueva. Do you still have a caseload?
I do.
Okay.
As a matter of fact, I don't know of any way to lighten your caseload. They say, well, you can slow up, but if you slow up, you go broke. So there's no in between that I know of.
Well, maybe it's a bad, call it a treadmill, but you're still on that treadmill.
That's right.
Okay.
Correct.
And
then also, what would you do if you weren't on the treadmill? Just like a judge asked me the other day in court, he said, girl judge, a female judge, a lady judge.
Edit.
She says, Mr. Nicholas, I thought you had retired. And I said, no, Your Honor, I haven't retired. Frankly speaking, I forgot to retire. And at the moment, I'm really too old to retire. So you're going to be seeing me in your court quite often.
Your golf game is so bad, you'd rather practice law?
The longer I play, the more I'd rather practice law.
Okay. Mr. Barrera, how about yourself?
I think Nick is being modest when he says that if he stops practicing, he's going to go broke. He's not going broke.
It's in the eye of the beholder.
That's
okay?
right. But he likes to practice as I do, and that's why we're still in the trenches and we're still representing people. I don't have any intention, my health providing, to retire. I am just delighted to come to the office every day and continue to do what I have done for many, many years in the past. I enjoy what I do. I enjoy trial work. I enjoy going out of town, meeting new judges and new prosecutors and new challenges. I think that helps to keep me interested in what we do. So unless and until something traumatic should take place or something totally unexpected, as one lawyer said one time, I will quit when they carry me dead out of the courtroom.
Okay. You know, we didn't...
Or the office.
Yeah. Well, I would think that this tape would be sufficient evidence that both of you are not lacking in mental acuity and to be able to remember things, and so that's certainly evident. We didn't ask anything about where were you born, where were you raised, but I know, Mr. Barrera, you're from San Antonio.
Yes, I was born and raised here in San Antonio, and incidentally, the beginning of my law practice was absolutely accidental and in a roundabout way. I had been in the service. I went to the Philippines in World War II and Korea and came on back. I had lost a finger in an accident, not in action, in an accident in Korea, so I became and was stamped a disabled veteran, as a result of which I could not re-enlist in the reserve, which was something that I had wanted to do, couldn't do, and so I became a disabled veteran. But I was anxious to get on with my life. I had taken auto mechanics in high school over at San Antonio Vocational and Technical School, and I wanted to be a mechanic. I was in the process of locating a place to do my duty and get married and all that, until my mother, God bless her, prevailed upon me to take advantage of the GI Bill and to become a lawyer like Alonso Perales and Jimmy Tafoya and people of that nature who she admired, and which I learned to admire also when I grew up. And so to please her, I decided to put my plans to be an auto mechanic on hold, and I went to St. Mary's University. Nick went to Texas University, which he lords over me, but I had a special reason for going to St. Mary's. At the time that St. Mary's was accepting students under the GI Bill, there were no girls being permitted to go there, and I felt that was an incentive for me, because knowing my frailties in the women area, that I would be less inclined to be distracted if I went to St. Mary's, an all-male school, as opposed to going to Texas University and endured the distractions that Mr. Nicholas endured. So I graduated from St. Mary's.
Alleged distractions.
Yes, I graduated from St. Mary's and then went immediately into the district attorney's office, and the rest you've heard. But my mother was primarily responsible for my becoming a lawyer. And of course, the GI Bill is one of the best things that ever happened to ethnic people, Hispanic people, poor people of any color, race, or creed, because Uncle Sam afforded us an education that we might not otherwise have been able to afford. And your Uncle Sam was smart in doing so, because it permitted me to make a living that permitted me to send my children, all of them, to college and to universities. I got 3 lawyers out of that, and they're now practicing law and making their contribution in taxes, as we all do, to the government. So it was well rewarded from the standpoint of the results. I have no regrets about that.
And Mr. Nicholas, anybody who knows you knows that you grew up in the North. You're from Austin.
I was born and raised in Austin, and I never thought any other place existed, because we always lived kind of in the shadow of the University of Texas and Memorial Stadium, and of course I went to all my schooling was in Austin, and then when World War II came around, everybody really wanted to be active in World War II. And so fresh out of high school, I joined the Navy, went overseas, came back, and as Roy was saying, we had the benefit of the GI Bill if you were a veteran of the Foreign War. And of course I went to the University of Texas, didn't know any other place anyway, and I started practicing really in December of '50, because I had enough hours to take the bar while I was still in school. So I started practicing in my last year of law school, but I did continue and get my degree from Texas. And the only reason I came to San Antonio was because I couldn't get a job in Austin. So my practice wasn't too good anyway. So I came here and applied at the DA's office. And at that time, Pat Maloney happened to be in the DA's office. I'd gone to school with him. And so I finally got an appointment with Austin Anderson, who had taken Bill Lindsay's place, who had just been killed in a plane crash. And finally got appointed, and I ran into Roy when we were sworn in. But then I found out later that my mother's family was from here, from San Antonio. I found out later that I knew Roy when we were about 8 or 9 years old. So I kind of think that the man up above will that we get together. And so this handshake business did take place. I don't recall shaking hands. But anyway,
a lot of things you don't recall.
But anyway, that's the way it began. It's really never changed.
I mean, there's the number of personalities that each of you and both of you could talk about just in this, your experience in practicing law. But you talked about the district attorneys you work with. We talked about some well-known defense lawyers and lawyers that you dealt with, but there's any number of names. Anybody that you just want to just pop up and say this is a person. Mr. Barrera, you talking about a trial with T.P. Henley, who is
Yes.
who
Yes.
carries a reputation. The Alcorta case was with Freddie Saman.
Right.
Ward Casey. All these guys are a separate tape.
Yes.
Whole separate story, but any stories you want to tell on any one of these guys, either one of you?
Well, very briefly, I want to say this, that not too long ago, I read a letter in one of our magazines where some defense lawyer, I guess it was a defense lawyer, he didn't identify himself or herself as the case may be, was commenting that you really were not really representing a defendant as you should as a defense lawyer unless you were on the outs with the prosecutor and you really had not earned your keep until you had been cussed out by a prosecutor and so forth and so on. And I found that to be disturbing. I wrote a letter back saying that as lawyers we are professionals and that we should keep and maintain a good relationship with lawyers on the other side of the table, whether it's civil or criminal. And as many cases as I tried, and I think that my prosecution record speaks for itself, I never had occasion to get angry at another lawyer, as many lawyers as I tried cases against, and they were hard fought and all that, but oftentimes we'd go to have coffee while the jury was out deliberating on the merits or demerits of our respective cases. And as a defense lawyer, I've never found it necessary to get angry or to curse or to get on the outs with a prosecutor. He's doing what he's supposed to do, which is what I used to do, and I'm doing now as a defense lawyer what I'm supposed to do as a defense lawyer. So there were many, many lawyers that we came in contact with: Leonard Brown Sr., Leonard Brown Jr., Gus Garcia, Abe San Miguel, T.P. Henley, Freddie Saman, Lou Schlesinger, Anise Saman, and there was just any number, and we always kept a good relationship with them, and I regret the passing of many of them because in my opinion there used to be a whole lot more camaraderie among lawyers at that time than there is now. It looks like we've gotten so busy or so involved in our respective problems and responsibilities that we are absolutely begun to disregard the friendship that can be kept and maintained among us as professionals.
Well, both of you should then come to Mr. Goldstein's house this evening, and there'll be plenty of camaraderie.
Good.
At 6:30.
Talking about Goldstein, I met him when he was a young lawyer in the 175th District Court, and he was telling me, Gerald was telling me that he had filed a motion to suppress in Judge Spears' court, and that he wanted to know if I'd be interested in assisting him because he was new in the profession. So I did, and we went over to Adrian Spears' court, who was the chief judge in the Western District.